Good afternoon, everyone. Welcome to Liverpool Advocates for Windrush Q&A session. Today is the 4th of August, and our focus today will be on the Windrush Compensation Scheme, more specifically under the section Impact on Life. And we're going to do a bit of a case scenario or a case study to really understand what it means, impact on life. And when you're filling the application, what you should be considering and doing rather than not. Welcome, Herman, for joining us this afternoon. Garrick, in advance of this meeting, I have sent out a link which we'll be using. So the link is, or the information is taken
Thank you.
from, you're welcome. The information is taken from the gov.uk website, and more specifically is the caseworker's guidance. Now, there has been an update to the caseworker guidance. We are again on the 4th of August today, and this version of the caseworker guidance is version 17.0. And it was updated on the 9th of July, 2024. It reads guidance for decision makers considering cases under the Windrush Compensation Scheme. Now, the reason why we thought that impact on life will be a good case study or scenario today is because there is clear misunderstanding on what is required under the impact on life, or what claimants should be thinking about and should be included in an application. So, as a case study, we have a claimant. I'll just use the letter S for sugar. S wants to make a claim under the Windrush Compensation Scheme and has had an impact on life as a result of being unable to prove that she had a lawful right to be in the UK. So she could not prove her lawful status. And the impact, basically the essence of her impact is that, one, because she couldn't prove it, she's been challenged at work, subsequently lost her job. She's been challenged at school through her children's school and found it really uncomfortable, irritating, and frustrating. And she would like to include her experiences under the impact on life section. The question then becomes, how does she do that sufficiently in order to show that because she could not prove her lawful right to be in the UK, her life was impacted negatively? If you follow me on the link, you click on the impact on life section in the left-hand column. It's just under homelessness and before discretionary payments. What I intend to do is to go through the caseworker's guidance, the latest version here, and talk you through using that case scenario of S and how we'll apply her situation to what a caseworker would look for when assessing an application. So if you're going to do your application at home or attempt it, these are some of the things you may consider including. It reads, impact on life. At any point, if anyone has any questions, please feel free to stop me or put up a hand and we'll have a discussion. This page tells you how to determine claims for compensation for impact on life. The impacts dealt with in this category are non-financial impacts only.
Sorry, Tanika.
Yes, Herman.
So sorry. I'm on the section for homelessness.
The next section is underneath that and above discretionary payments, impact on life. So if you scroll a bit further down, you'll find it.
I'm on impact of life now, yeah?
Yes.
Is that the right area, yeah?
Yes, and I just read the first paragraph, which is this page tells us how to determine claims for compensation for impact on life.
Thank you, excellent. Thank you, I've got it.
You're welcome. No
Tanika,
problem. Yeah, Garrett?
because I'm using my phone, I haven't got the full. So I'll use my pen as a way of showing my hand.
No
Just
problem.
just before you get into that section, it's worth noting that the standard application that we encourage people to read the guidance before they make the application. Section 12, which is impact on life, it then directs you to the caseworker guidance, page 82 to 86, which is the one that you're going to be dealing with now. So this is why it's important that when we say to people, they must follow the guidance, read the guidance. And in addition to reading the 44 pages guidance, they should also read what we're now going to be examining, the full caseworker's guide, because that is where the caseworker is using information to make decisions.
Thank you for that, Garrick.
Thank you.
I'll reread part of the first paragraph because there's some important information in there. Actually, I'll read the entire first paragraph. It's only 3 lines. This page tells you how to determine claims for compensation for impact on life. The impacts dealt with in this category are non-financial impacts only. Therefore, financial losses or impacts should not be subject of awards under this category. Under the impact on life, that first paragraph says quite clearly that it does not relate to financial impacts you may have suffered. If you've had financial losses or impacts due to your inability to prove your lawful status, under the section Impact on Life, this is not where you include it. There are other sections for that. What does impact on life mean then, if not for financial losses or impacts? I'll come on to that shortly. Then the second paragraph, which is a sentence. Claims under this category may be made by the primary claimant, the estate representative, or a close family member of the primary claimant. Detrimental impacts can include, so this is what you can claim under impact on life, the following areas. Inconvenience. What does inconvenience mean? A lot of things inconvenience us in our lives. Specifically on the impact on life, here the examples that they have are hardship lasting no more than a few days. For example, one-off cancellation of appointments, short-term deprivation of money, small financial losses, or losses of opportunity or delays that have no material impact. What does that mean? That says a lot. Simply put, if you wanted to attend an event, but to attend the event, you have to prove your identity, but you don't have any valid identification because you never needed it. You've now become attained age of majority, i.e. over 18 years old, or you've been in this country since an adult and you've lived here for 30 years, but you never really needed to prove your identity. You lost it recently because you moved homes or something like that. And you want to do something or go somewhere and you cannot prove your identity. You have to cancel your trip, your appointment. Short-term deprivation of money, you lost a job. But before you can get another one, you kind of run out of money. So inconvenience. This is something we will happily discuss with you if you think applies to you. The next bullet point, injury to feelings. As examples of that, anxiety, distress, and reputational damage, worry, annoyance, and similar emotional impacts. Traumatic or highly upsetting experiences, embarrassment or humiliation. Okay, so how does that work? If you've had an experience where you may, for example, being in a conversation and they were saying, somebody said recently, a claimant, that they were having a conversation. This is still applicable to claimant S as the case study we're using.
Yeah.
Being in a conversation and they were speaking about being British and being able to go places and not having the hassle of having to prove their identity, possibly because of their ethnicity or possibly because of their accents. But nonetheless, you felt, well, I couldn't. And I don't want to say, well, I don't even know if I am British or not, even though I've been here long because my parents are from the Commonwealth. You start feeling a bit anxious, nervous. You don't want to, you just want to come off of that topic. You don't feel confident. You feel embarrassed. Now, when they do ask you, because you're part of the conversation nonetheless, you don't really know how to answer. When you said, well, I'm British, I've lived here all my life. But were you born here? Somebody asked. No, I wasn't born here. Or your parents weren't born here. Well, you're not really British. You start feeling a bit humiliated. Your feelings get hurt. That is what is meant by injury to feelings there. A lot of people do not consider that as impact on life. Or if they do, how do they put it over in an application? We can help with that. The next bullet point, deterioration of physical and/or mental health. Here it has experience of pain or illness due to either new condition or exacerbation of an existing condition. I've had a client, and I'm sure it possibly could relate to claimant S. We don't know because it hasn't been explored. But if claimant S, for argument's sake, had an underlying health condition, and when they realized, well, as of, for example, 2014, when the government made it mandatory for employers, landlords, and people of such ilk to question and confirm that individuals had a right or lawful status in the UK to either work or to rent, that person's health condition became worse because only then they found out, well, actually, you're not here legally, or actually, your lawful right to be here, or legal status, or settled status was revoked, or it lapsed, or whatever the case may be. Just like this is stress can cause different illnesses, the illnesses then get worse. That links to deterioration of physical and/or mental health. The next bullet point, family separation. Under there, it has inability to meet with close family members outside of the UK. Breakdown of the family unit. A lot of people's families have, unfortunately, have been broken up, and in our case scenario of S, this does not apply. But if it does in your case, and your home, as the common thing goes, fall apart or got broken up because you're stressed, you're worried, you're anxious, therefore you have a shorter temper, you're more irritable, you're snapping at family members and vice versa, the family unit break down, and therefore the home breaks. Yeah, Garrett.
And here's an example of that, when you think about those who've been locked out of the UK, separated from other family members that's in the UK, that is very common that the family would experience all those issues. And that was the case for a number of people, including Mr. Richard Black, and also even Roland's own case was separated from his family members before he had to, come back to the UK. So this is a big issue, and some people sometimes just give up because they're outside the UK, and they just give up because they've tried to make contact with the local British embassies, and they don't get any reception at all to even enter the building, and they just give up. Decided, well, they can't be bothered. Now we know, for some people, the 2-year rule is the one that has prevented them from re-entering the UK, because they had to leave the UK to deal with family issues abroad. But also just think about the stress, the anxiety, and all the other issues that comes from family members being separated.
That's a very great point and contribution, Gareth. Thank you for that. We will come on to areas that deals with that a bit further down in the reading. However, the next...
Can I just make a comment?
Yes, go ahead, Herman.
Or maybe you want to come to it at the end of this section. I'm not sure. On the area with regard to what evidence would you say would be needed with regard to the mental health and so forth? Are you going to come along to that with the family separation? Are you good with regard to what evidence would be needed?
We come on to the evidence section is just underneath this here.
Right, okay, thank you. Okay, don't worry. Thank you.
But just whilst we're here, I can touch on it briefly if that will make it easier. But we will come on to evidence. Or actually, no. Can you save the question? And when we start on evidence, if you can ask again if it's not covered in this section there, that would be easier, I think. Yeah? All right, Herman, you're back on mute, so I think that's as a yes, thanks.
Yes, okay.
All right. The next bullet point was inability to attend significant family occasions. Now, this one, when I read it, to me, it seemed like definitely an update, because I was under the impression of significant family occasions are indeed weddings and funerals, but are there significant things to you? Why was it significant to you? And you would have had to demonstrate that it was significant, but you missed it. But here it says weddings and funerals only. Not christening, for example, or graduations, or something else that's significant to you, only weddings and funerals. The next bullet point, inability to work because of deterioration in their physical or mental health. And last bullet point, inability to return to the UK, for example, after a holiday abroad or a short period of time spent outside the UK. In summary, all of that, this applies to people outside of the UK too. And as Gareth was saying earlier, for example, not being able to meet close family members from outside the UK, that is something that you could include within your application. That's something that our claimant S can include, even though that was not part of how she had been impacted. But that was just a perfect example to show that most of the times claimants do not consider these things. But these are questions we will say, have this happened to you? Have you thought of this, or have you considered that? Moving on, claimants may cite a range of impacts which have had a detrimental impact on them, and each case should be considered on its own merits. You should consider whether the claimant has experienced a loss or a disturbance in their everyday life because of their own or of a close family member's inability to show their lawful status. Again, it all revolves around being unable to show your lawful status. That is the single fundamental question that needs to be answered in the affirmative. Basically, yes, because I was unable to do this, or because I was unable to show my lawful status, I was unable to do A, B, and C, or go through the entire alphabet. You will need to determine the significance of the impact on the claimant. Some impacts, such as inconvenience or hurt feelings, may be relatively minor and short-lived. Others, such as a deterioration in physical or mental health, may be more serious and longer lasting. Inability to attend a family occasion may be a significant impact, but may not be of long duration. The significance of the impact and the supporting evidence is what will determine the tariff payment you should award. So we're now coming on to evidence, supporting evidence. All claimants should provide information to show that on the balance of probabilities, the primary claimant, the deceased, or the close family member experienced detrimental impacts as a result, as a direct consequence of being unable to demonstrate lawful status. I'll repeat that one more time. All claimants should provide information to show that on the balance of probabilities, this is the legal standard, the primary claimant, the deceased, or the close family member experienced detrimental impacts as a direct consequence of being unable to demonstrate lawful status. In relation to lower level impacts, such as inconvenience or distress, information and evidence may just be circumstantial. For instance, distress and upset caused by the inability to demonstrate a lawful status. You may take at face value a statement that a claimant has experienced inconvenience or distress when the facts of the claim are considered. So for the first two paragraphs, the evidence you need to show if you suffered inconvenience or distress, it will be on the balance of probabilities and it will be taken at face value. One of the things that we found hard, even if you say, for example, oh, well, I have, as our case scenario S, well, my employers asked me for to prove my status and I couldn't. Or my children's school and I couldn't. And they kept asking and kept asking. So I then had to go sort it out, even though I've been here for years and did not have been here for years. But I lost and they needed me to prove it. That caused distress, that caused upset, that caused embarrassment, even humiliation. So the caseworkers, when they're assessing your claim now, they'll be thinking, how likely did this happen? How likely was it that this has happened? And based on their judgment, if it's 51% or more, like, okay, yeah, we possibly can make an award. We'll come down to tariffs and what that award may look like. Pardon me. Or they're like, no, we don't think that that's a high probability, so we're not going to make an award on that. Moving on to the third paragraph. Impacts that have a greater effect on a claimant might be accompanied by directly relevant supporting information. A claim for impacts on mental health. Sorry, I'm reading mental and reading mental health. A claim for impacts on mental or physical health can be supported by medical evidence of the detriment suffered and an opinion that this was caused by or exacerbated by uncertainty over lawful status. Herman, I believe your question earlier was around this. Before you comment, Herman, Egbert, I see
Yeah.
your lips moving. I'm not sure if you're trying to say something, but you're on mute. And welcome.
Could you hear me?
Yes, I was just saying to Egbert, I see his mouth moving, but he's on mute and I could not hear what he was saying.
Oh, sorry, I thought you were talking to me. Sorry.
I was, Herman, I just asked if you can just hold on a minute before I looked over to the screen and saw Egbert's mouth moving, which was
Okay.
distracting me.
No worries. No worries. That's okay.
Egbert, you're on mute and I can't hear you. You're muted. If you can hear me, you're muted. But okay, I'll just, sorry, Herman, it was just, okay, I don't know if it's just
No
me.
worries. Okay.
But going back to you, Herman, my apologies. This paragraph that I just read deals directly with mental health and the evidence needed. Does that answer your question from earlier?
With the mental health, it does to a degree. Yeah, it does brush on that. Although I was just thinking, I know with some people to prove a big problem with employers has been if you can't more or less produce it there and then, it's goodbye. Yeah.
Yeah.
And then the person's left basically with not ever having any sort of written documentation given. Some employers are good enough to give a letter, or in the short term, send a letter on, or even sometimes after a request, send information to that. But for a lot of employers, it's basically as soon as that's seen, it's known that maybe there's an issue about your identification, and you can't state that. Bang, it's virtually straight out the door. There's people I know with that where some haven't even been allowed then to even clear their desks. Security have done that because this has happened to people in public who've worked as public sector workers as well in clerical positions. Yeah. So I've listened to what you've said there. I don't want to get sort of too much ambiguity about it, but it's trying to get as much information as possible. I know with the medical evidence, I know you have said previously where is it now the Home Office could request that or pay for that? Is it the report or something?
I'm not sure. I don't want to say yes. Garrick, I see you have your hand up. I'm not sure.
Yeah.
Normally,
Yeah.
with the medical evidence, you can request it. I think there's a small fee that you normally have to pay to get the records.
Yeah.
Whether, if, for example, if you cannot afford it, then you can ask the Home Office, why not? And
To
see if
me,
there's something that they can help with. But
yeah,
I'm not 100% sure, Herman.
Yeah, I mean, it's just sorry, Garrick. I just want to make this point. There's a difference with regard to having a medical statement with regard to what ailments or even what medicines you've had over the year.
Mm-hmm.
That's the difference. If you look as a more critique report, yes,
Yeah.
with regard to what you've had, and that's my issue. Is there rather than going for the light touch, which is the statement, yes.
Mm-hmm.
It's the report that would actually, I think, have some of the real resonance which is in there. I've yet to test that, but I'm coming up to that where I've got to make those sort of decisions on over one or two clients. So, but thanks for making that clear for what you've said there. I think Garrick's got to say something because you want to make a comment.
Yeah, but before you do, Garrick, hold on for me, please.
What do you think of what I've said there? Does that make any logic or what I've said there? Or
It does, Herman, and I want to add more to it, actually. So even though you can get a medical report or a statement to say, well, yeah, you have mental health conditions or physical conditions, those conditions has to be related either directly or indirectly, but the medical evidence or doctor expert has to say, as a result of or over, as it says here, your lawful status. And if said conditions that you've had before or never had before, so it depends. The one you've had it before, but as a result of your lawful status situation coming up now, it's been exacerbated or gotten worse.
Yeah, I understand that.
Or if you've never had it before, but having found yourself in difficulty with your lawful status, you then develop these conditions. Either way, the medical report has to say something, either for, i.e., you had it before, or didn't. So it has to make that very clear, basically.
And that's why the doctors are charging money. Okay. I understand what you're saying there, and I know that's going to depend on relationship people have with the doctors. As I said, I don't want to get to get it ambiguity about it, but I understand what you're saying. But do you understand what I'm saying? There's nuances to this. And sorry, I think Garrick wants to come in. Sorry.
Yes, Gareth.
Thanks for that, Tanika. Thank you. Thank
Yeah,
you. For that.
just picking up on a couple of points that Erman has mentioned and what Tanika has said. A claim for impact on mental or physical health supported by medical evidence. And we always encourage people, if it's not necessary to pay for a full report, then don't do it. You start with the patient summary from your GP. That will give an indication of when your situation started, how you've been treated, what medication you're taking for that particular condition, and also if you've been referred to any consultant in specialist service, such as a mental health hospital, for any period. All that information will be available free of charge on the patient summary. If something more detailed is required, then there may well be a cost for that. But we don't encourage people to go down paying for a medical evidence unless it's absolutely necessary.
Thank you for that, Garrick. Also, Herman.
Yeah, can I just make a comment on that? Okay, I could see that. Oh, this is almost like a chess game now. This compensation scheme. I could see what you've actually said there, Garrick. Your initial actions are with regard to that would give, quite an understanding with regard to that there is some relevance, there is some evidence with regard to some realism in the claim as such. However, if something deeper is needed, that actually that's it. Then that's when to request it, not straight up front. So I suppose, I'm sorry, I'm sounding like this. Like it's not a game. It's very serious here, not to show your hand, the full hand straight away. So I could see what you mean there. Because see, with me with drafting this, I would try to ensure that with regard to the medical evidence and what's got down on paper, it makes common sense. There's a resonance there with regard to something that's been exacerbated to what you've had before, or something that's come about because of the situation which you are now there. But I could also, I see what Tanika said, how she's explained that. It's good. That's one game plan. And I've listened to what you've said, Garrick, as well. So I understand that. So thanks for that.
I can also mention, Erman, that we know families who, as a result of their experience, have ended up in a mental institution. Not just one member of the family, but more than one member of the family. And we can identify the date when that started. So, these situations, and it often is the case when we say to people how you answer question and what you will, put and explain. Some people may not answer the question appropriately, and the Home Office caseworkers might just dismiss what's being said because enough information in that question wasn't to the point, and they just make the decision that that person doesn't really qualify for this because of what they said. And that is why we encourage people to seek help. It's important to draft your response firstly, and then have somebody to look over it, and preferably an advocate to look over it, who can actually say, well, you haven't got enough information here about it, and ask some additional question, abstract the information from the individual, and buff out that statement much better in response to the impact and the various aspects of loss or what they've suffered.
Picking up on that, thank you
Yeah.
for that, Garrick. One moment, Herman. So picking up on what you've just said, Garrick, one of the things that we encourage is that you don't have to go and ask for medical records because you don't know what you'll need. So again, going back to how have you been impacted? This is not a financial category. So once we as advocates know, or if you're doing it yourself, how have you been impacted? Can it be supported, or can I show medical evidence to support what it is I'm claiming? So, for example, taking our claimant S case scenario that we're using, her employers made it difficult on her and said, well, we need to see your documents, even though she'd been working there for some time. Her children's school required proof of her lawful status. She's been mentally affected. The question then becomes, did you report it to your GP? Do you have medical evidence to show that you became depressed, that you became anxious, especially having to attend your children's school for parent meetings, for example, or if for whatever reason you were called to the school? Do you have any supporting information that's relevant to what you're claiming? So this is where medical evidence is essential to support your claim.
And that's a
Unfortunately, it's
really
going to
good point,
be
Tanika.
one
That's a
second,
really
Garrick. It's going to be difficult to say that, well, I suffered with this, I experienced that, and not be able to prove it. If you cannot prove it, the Home Office will be thinking, well, anybody can claim anything. Anyone can say something. Oh, this happened to me, that happened to me, but where is the evidence? And if they don't, they'll be opening the floodgates for arbitrary claims on people who weren't affected to just try to claim financial compensation when the people who were genuinely affected will be deprived of their compensation because they'll be coming up with these fanciful stories and you might miss out. So you need to be able to prove, show that you were affected. So in our case scenario with S, we will have to say to her that, did you report it to the doctor? It's not a problem if you haven't, because you can still go and say to the doctor now, well, I'm making my Windrush compensation claim, and this happened to me back then. The doctor can write a report and say, well, this person attended our clinic, GP surgery, whatever. They presented with this, they said that. On the balance of probability and their medical professional experience, they can, say whether it was likely or not, or looking back at your medical records, whether yes, it's probable. It's not a problem if you didn't report it at a time, because a lot of people want to think, well, I'll go report that I'm depressed, having to go through this. You try to do it on your own, especially people from Commonwealth nations. They just get on with it. That's the culture. So please speak to an advocate. Yeah, Herman. Derek, I'll come to you in a second. Herman, you had wanted to say something before?
Yeah, just quickly, I agree with both you and Garrett, and this is the nuances where I know hovering, but I've got to be careful because I know you basically want to become qualified as a lawyer and solicitor. This is where I know the eagles are swarming above, because basically it's the nuances with regard to that. And I hear, oh, this is why you need the legal help. You need to have lawyers and solicitors, barristers getting it. And I could understand that, because someone could give an answer perfectly correct English, grammatically correct. However, in the caseworker's eyes, which actually should have a world eye view of these things, we know it's more myopic, more narrow-minded, as it were. Yes. What you've actually done is, if like, you've actually reduced your chances of with regard to mitigating your case. So yeah, I understand that. I understand what you've said and Garrick have said, and this is the issue, a major issue, because I think I'm getting some people coming through now who have failed, made applications and so forth, and you could see where it could have done with a bit more sort of beef, so to speak. how they've done it, and or someone to look at it initially as well before it's even gone off. All right, thank you. I'll try not to interrupt too much because I know for time purposes and so forth. But yeah, that particular area. Thanks for clarifying that, both of you yourselves there. Thank you.
You're welcome, Herman. It's not a case of disturbing or interrupting. Please do ask if you have a question. This is about sharing information. One of the things I must say that we don't know everything. We're here to learn from each other. I may have one interpretation of the material in front of you, but you may have another. So it's about sharing. Okay, so please interrupt as much as you need to because somebody else may think the same or be thinking the same. We're here to learn from each other. So please feel free to ask questions, Herman. Garag?
Yeah, just picking up on the point you made with regards to how an individual answer the question, and it may be, did you report this to your GP? And the answer is either yes or no. But it's not as clear as yes or no, because there's some people who've never had a GP, and they're not registered with anyone. That's more difficult to actually manage. But I also know of Africans, a good friend of mine who have lived in the UK for many, many years, and he doesn't register with the doctor. And he always says, if anything wrong, he just go to the hospital. He's never registered with a doctor. And that's what that's his life for 50 odd years. So not everybody will register with a GP, but there's also the understanding that you have what we call primary care. So the GP provide primary care services. Then you have what we call secondary care. That is when you've been referred into a secondary care hospital for treatment, etc. And an individual can spend, weeks or months in a hospital for both physical or mental health. And so, if the person does have a GP, then GP record will show all that information as to when the person went in and came out and how they were, what was the complaint, etc. If they haven't got a GP, then it's a different scenario to deal with. And as you just said, they can now go and see a GP, or go and find a GP and let the GP know what's been happening to them, and this will be retrospectively because that may be their history. So it's not as straightforward as one would think, as the question will ask yes or no.
Thank you for that contribution, Gareth. In addition to that, for your friend, for example, having been to the hospital, all his life or for over 50 years, he can get a copy of his medical report from the hospital.
Absolutely.
So it's still supporting information or evidence that can support his claim. If, for example, he was eligible to make a claim. The point that I was making and I'm making is that it's not impossible to get retrospective information, as you said, Garrick, to support your claim. So please don't think, well, it's the end of the world. Figure of speech pun intended.
Mm-hmm.
Yeah. It is possible. Welcome, Neil. Moving on to the next paragraph. Where it is claimed that a pre-existing condition has been made worse, you should consider the degree of exacerbation, acceleration, and nature of contributing causes when determining the level of tariff to award. So again, even if you've had a pre-existing condition and then you found yourself, well, I need to do something about my lawful status. I never considered it before because I never traveled out of the UK since I've arrived here at age 5. But now I would like to go on holiday with my family for the first time. I have my own family now. And then you found out you couldn't. In our case scenario with S, if S wanted to take her children on holiday, but because S was born in the Caribbean, for example, and her children therefore adopted her identity and are not yet British in their own right, because probably they haven't attained the age of 10 years old and they don't have a British father, then she cannot go on holiday. And her pre-existing condition, which she has a heart condition, it was made worse now by her employers in the school asking for her lawful status to prove it time and again, that her heart condition palpitations got worse and caused her to have maybe even panic attacks. Now she had to go to the doctor. There's evidence of that. So these are things that will need to be included under the impact on life. And that's a perfect example of demonstrating a non-financial impact on a person. Moving on. Where a claimant says that they were unable to work owing to physical or mental health impacts caused by issues over lawful status, they might provide medical evidence which demonstrates, one, that they were unable to work together with an opinion that this had been caused or exacerbated by concern over lawful status. And two, evidence that they were in employment and the period for which they were unable to work. This period may be evidenced by sick notes signed off by a medical practitioner or a letter from the employer. So going back to S now have medical evidence from the GP saying, well, this has caused her to have panic attacks because she could not prove her lawful status. And then it's affected her home life with the children. But again, it goes back to evidence. We're now the evidence section of impact on life. You have to prove it. And where there's no proof, explain why there's no proof. Maybe it falls under the category, as we covered earlier, inconvenience or distress. Again, if it was to do with employment, did you get dismissed from your employment? Do you have a P60 or P45? What evidence do you have? A letter from your employer. You should not expect medical evidence to be provided in all claims. You should consider whether you can make an award on the balance of probabilities without the need for further medical evidence. If you think medical evidence is required, you should first consider whether any information is likely to be available from existing sources, such as a GP. One of the things I would like to add there too is that, say for example, you've been with a GP for over 50 years, and only one aspect of your medical illnesses that you may suffer has been affected by your inability to prove your lawful status, you then do not need to ask for your entire medical history. You can ask for the one section that you think has been affected. So for example, in our case scenario with S has multiple issues, but only her heart condition has been, to her knowledge, been affected. So she can ask just for information around that. It may be a case of the doctor turn and say to her, well, actually, this can cause further problems, such as you becoming stressed, which produces more cortisol in your brain, for example, or more chemicals, I'll just say chemicals, and therefore cause problems with your kidney, your liver, different organs. But a doctor can give you further information, things you may not have considered. If this is not available, you should consider requesting an independent medical report. See the referrals to medical experts section for more information. Where a claimant says that they experienced family separation or inability to attend family events, they might provide information or evidence in support of this. This may take the form of documentary evidence in the case of a legal separation, or circumstantial information in the case of any other separation or of an inability to attend a family event. In the case of the latter, i.e., inability to attend a family event, this should be a significant event such as the birth or marriage of a son or daughter, or the funeral of a son or daughter, funeral of a son, daughter, mother, or father. This contradicts something that they said above, i.e., they said above marriage or death only. When I said my interpretation was also about births, that's a significant life event. In here, they're now including birth. Similar to your ambiguity statement, Herman, unfortunately, there are ambiguities within the information the Home Office provides, and we will try our best to either clarify it based on our interpretation and understanding, and or write to them and ask them, the Home Office, to provide said clarity and understanding so that we can better help you. You should ensure that you do not include in the impact on life category any impacts that will be more appropriate to consider under other categories of loss, which we've said earlier. I just want to go back briefly to the paragraph that I just read before. It says, experience of family separations or inability to attend family events. I'll reiterate from one of the earlier paragraphs with the bullet points. Here, the Home Office says only for death and weddings. Those are the only two that are considered under impact on life. Here, it says births or funeral, daughter, son, mother, father. Now, suppose that your parents or family members who've died that are close, because these are nuclear family members, they've just listed here. Pardon me. They're abroad and you're in the UK. So could you not attend that? So, for example, if S was unable to go back for one of those individuals' wedding or death, that is something that can be included, even though the only thing that she knows that she consciously suffered was, one, her employer asking her to prove her lawful status, and two, the school asking her about her lawful status because her children attended there. That's all she is able to think about because that's what happened. But these are things that we will also consider and explore with us. You should take account of all relevant circumstances and available information and evidence, and pay particular regard to the severity and duration of detrimental impacts, adopting a balance of probabilities approach. So we're just about to conclude the section on evidence, and we'll move on to the impact on life tariff table. You should determine the amount of award payable in accordance with the tariff set out in the impact of life table. Does anyone have any questions on evidence? Okay.
No.
All right, thank you. I'll move on. Level 1. You have levels, description, and remedy amount. Level 1 is equivalent to the old level 1. Description, marked detriment, marked detriment, such as inconvenience, annoyance, frustration, and worry, where the effect on the claimant was fairly short-lived, lasting up to a few weeks. Family events may have been missed. Remedy amount, £10,000. Level 2, equivalent to the old level 2. Description, moderately severe impact on some aspects of the claimant's life over an extended period of time. for example, weeks or months, or where multiple cumulative impacts were suffered for a relatively short period of time. Claimant may have been unable to engage in activities which they were previously familiar, although should still have been able to live a relatively normal life for much of the time. There may have been an inability to attend one or more significant family events, or there may have been family separation. Here, that is £20,000. Taking her case scenario S, now S has been affected over a period of months. Her employers repeatedly asking her, having to attend school frequently, and asked by the teachers and those working in the school for proof of her lawful status to be there, therefore disrupting her children's education. One of the questions we'll need to ask S is, well, how has it affected the children? Has the children appeared withdrawn from their studies? What has the teachers reported? So these are things all that we'll need to consider.
And one point to add, Tanika, when you
Yeah.
said about the children, for example, the children behavior at school might be disruptive, and teachers may having to deal with that situation, either exclude the child or maybe bring the parent into the school and discuss these issues, and could even be warning. But all these things will be documented, so there will be evidence.
Thank you for that, Garrick. 3, equivalent to all levels 3 and 4. So here, one of the updates, this has been merged. The old levels 3 and 4 are now level 3 only. Description: ability to live a relatively normal life. Before I continue with level 3, the statement relatively normal life was used in the level 2 above. What is considered a relatively normal life? I'd like to ask. In my opinion, that's subjective. And being of Caribbean heritage, I say that from a lived experience perspective. What I've witnessed with claimants and knowing African Caribbean cultures is that we find it harder to have a relatively normal life on a daily basis. For that to be coupled with the stress, anxiety, concern over your lawful status, even when you were born in the UK, raised in the UK, the only home you know is the UK, you've never left the UK, to then be told you're not British, you don't belong here, you belong to somewhere, somewhere else, another country. There's nothing normal relative in that, in my opinion. I go back to level 3. I just wanted to add that in. Ability to live a relatively normal life was substantially affected. More than one area of the claimant's life may have been affected, and overall impacts were significant. Cumulative impacts will have been experienced for an extended period, several months, with recovery or a return to normal life having taken a reasonable amount of time. Short periods of focused medical treatment may have been necessary. The award for this is £40,000. As advocates, we appreciate that the African Caribbean cultures, because that's predominantly where the Commonwealth nations are that have been affected according to the Home Office from the 65 countries that they've listed. This does not include European countries because Europeans do fall under the Windrush scheme also, is that we have our culture is one where we just like to get on with things. Sorry, and I say African Caribbean, that does not exclude Asian cultures. So my apology for not making that clearer, because you do have Asian countries from the continent of Asia affected also, and included within the 65 countries, the Commonwealth nations. We have the attitude of just getting on with it. And that has its own issues in its own right. We do not appreciate the significance of mental health impact. For example, I am Caribbean. So back in the Caribbean, when we see someone we consider to be mad, we do not appreciate that they can be having a mental health issue. We just use the word mad, and that's it. However, living in the UK, you learn that no, it's not mad. It could be several reasons. It could be a mental breakdown because of loss of a home, job, family, whatever. Or it could be for other medical reasons, and the support system is just not there. And gonna get on with it attitude has not worked. Short periods of focused medical treatment may be necessary. That may not be available, especially if you, like Eric earlier said, you caught yourself under the 2-year rule under the 1973 Immigration Act, where you were locked out to the UK because you've been out of the country for more than 2 years and no longer are able to access the medical treatment you need. What then? So there's lots more to consider. Or your parents, for example, fell into that boat and you're here, your parents are back in Asia, Africa, Caribbean, wherever in the world you're from or your parents are from. What happened then? They don't have the same level of treatment, given the fact that most of the other countries are third world countries, and this is a first world country. Moving on. 4, equivalent to the O level 5. Description. Significant impacts to the extent that a claimant's ability to live a relatively normal life was seriously compromised. Cumulative impacts will have been experienced for a prolonged period, months or years. The claimant's life will have undergone change of some description, such as having regular medical treatment, care visits, or other therapeutic intervention, with recovery taking a significant amount of time. The remedy amount, £70,000. And 5, equivalent to O level 6, profound impacts on a claimant's life, which are likely to be irreversible. This is expected to involve major physical or mental health impacts, where the claimant has been permanently affected or where recovery or return to a relatively normal life is likely to take or has taken several years. Award, £100,000. Because it is not possible to anticipate every eventuality that may arise, there remains scope to award more than £100,000, where an individual's circumstances are so compelling or severe, it would be appropriate to do so. You should refer these cases to your team leader in the first instance. These decisions should be taken on the facts of each case. Before we move on to initial assessment preliminary award, does anyone have any questions on the impact on life tariff table?
Not at the moment. I'd have to study it a bit more. Just the comment is that there's quite a steep rise between that 40,000 to 70,000. I don't know how they've cobbled that together, but yes, it's just been interesting, especially where you've mentioned where you may well be out of the country and you can't get some of that help and support and so forth. Yeah, it's interesting. But yeah, I'll have to do some delving into that. But thank you very much. I'm enjoying this session actually. That's good. Thank you.
You have me smiling, Herman. Sorry, you may hear me trying not to laugh in the background. But
For one. Thank you.
And likewise. Initial assessment and preliminary award. You should carry out an initial assessment of the impact on life category within 6 weeks of eligibility being confirmed. Based on the information and evidence provided with the claim, you should determine whether the claimant or deceased suffered detrimental impacts as a result of being unable to demonstrate their lawful status, and therefore meets at least level 1 on the tariff table. If you are satisfied on the balance of probabilities that the claimant or deceased does not meet at least level 1 on the tariff table, but to fully consider the claim will take longer than 6 weeks from when eligibility was confirmed, you should offer a preliminary level 1 impact on life award ahead of the remainder of the claim being fully considered. Reflecting on the 2 first paragraphs there, it is worth considering if you have had an impact under the impact on life category when completing your application. If you're unsure, reach out to an advocate wherever you are. Once you have fully considered a claim, if the final award for impact on life is higher than level 1 and a preliminary payment has already been paid, you should deduct this from the final award offered under this category. If you're not satisfied on the balance of probabilities that a claimant or the deceased meets at least level 1 on the tariff table, and to fully consider the claim, you will take longer than 6 weeks from when eligibility was confirmed, you should inform the claimant and proceed to caseworking the claim more fully. So again, this is about the third or fourth time the period of 6 weeks is mentioned from when they confirm eligibility. So once you're sending your application and you've received notification, well, okay, you're possibly eligible or there is eligibility by the Home Office, you can start counting 6 weeks from then for when you'll have a decision on the impact on life section. So going back to what I said earlier, it is worth considering completing the impact on life section. 6 weeks is only a month and a half.
Yeah.
Go ahead.
Yeah, thanks for that. Because obviously, without saying it, it's quite a heavy. It's given quite a heavy weighting, isn't it?
Yes.
Impact on life. If you could talk about if they tot up the marks, as it were, for awarding the claim. So, yeah, we've got to look out for that one. Yeah. So it's interesting what you've said there. Thank you.
You're welcome. If within 6 weeks of eligibility being confirmed, you are satisfied that you have all the information necessary to fully conclude a claim, you should issue a full and final decision. In my experience, I have read decision letters where the Home Office would say, do you have any forward information you would like us to consider? Or can you provide more information on this? So they do give you a chance to explain further. Going back to the scenario of S, this is something that we would encourage S to think about. And again, to make clear, the initial offer of level 1 payment of £10,000, that is just that, the initial offer. Preliminary level 1 impact on life award, to be exact. That does not reflect your full and final payment. When that stage has been reached, the Home Office will make it clear that this is what we would like to offer you for full and final payment. Do you accept? If there's no questions on the initial assessment and preliminary award section, we'll move on to referrals to medical experts. And after that, we have the last section, which is balance of probabilities. Okay. Where you think a medical report could result in an increased offer of compensation. For example, where significant or irreversible mental or physical health impacts are claimed, but are not apparent from the information provided. You should consult with your team leader to decide whether to seek the opinion of a suitably qualified practitioner. You should also consult with your team leader when a request to commission medical or other expert evidence is received from a claimant or a claimant's representative. So if you claim to have a medical issue, but you do not provide evidence, the caseworker working on your case will have to consider whether they, one, recommend that you go to the GP and provide medical evidence, or whether they can consult a medical or suitably qualified practitioner. Alternatively, if we were to send the information to them, then they will have to get it reviewed, which is fair. If there is no medical evidence, you should consider why this might be. Going back to the example that Gareth offered earlier about his colleague or friend of over 50 years who do not have a GP, but goes to the NHS, he may not have thought to contact the NHS to get a report or his medical file, and therefore may not have sent in medical evidence to support it, his claim, but he can. So this could be why, for example, in his case, he didn't send. I'm just assuming that this man may be eligible as an example. A claimant might not have talked about status-related health impacts with their GP. They might not have been aware their health was being impacted at the same time they were experiencing status issues. You should still consider whether it would be appropriate to seek the opinion of a suitably qualified practitioner. And this is so true because a lot of people aren't medically qualified, so they would not make the link of them stressing out about their lawful status to them having, for example, migraines or headaches, or feeling ill, or starting to suffer with anxiety, or having panic attacks, and the list goes on.
Can I just come in there?
Yes.
I should have said it earlier. I know there was a report which came out this week, and the pandemic actually showed how things got exacerbated with people's conditions. But there is an issue in this country where people soldier on with various ailments and issues, not seeing their doctors. Yeah. And in actual fact, they're thinking they're being an asset at work, but in actual fact, they're not as productive as they could be. They're productive, but as not as productive as they can be
but many ailments lie basically unfound or actually get worse, exacerbate over a period of time. Yeah. And then suddenly it hits them and everyone wonders, cause, they were operating well. In actual fact, they were incapacitated in some way, shape or form. Yeah. But
Yes.
this is an area such, almost that British stiff upper lip sort of thing of soldiering on. A lot of people don't report things as such, and it's so important. I know doctors have got so much on, but even if you just make that clear at the reception and make a note and let the doctors know and so forth, you've got to let them know, because that's the sort of stuff I can see people miss out on way. But there isn't a culture of reporting things. I'll qualify that. The government are finding out that it's starting to turn now, yes, with the number of people who actually are off work with ailments of those claiming there's a PIP support, with regard to benefits. So it's quite interesting reading this, what you're saying here now. So people need to be savvy, basically, in their approach with dealing with this. Thanks for that. Thanks. I understand that.
You're welcome. You must obtain the claimant's consent to commission a report. Oh, sorry, Garrick. Let me finish off this sentence. I just
go ahead.
heard and saw your pen up. You must obtain the claimant's consent to commission a report, the cost of which will be met by the Home Office. So going back to the earlier two paragraphs, if the caseworker thought, well, why did this claimant say they have medical issues but did not provide any evidence of it, and they would like to look further into it, that is what that says there. They can, with your permission, they can commission a report and the Home Office will meet the cost. You would not have to pay a penny. Go ahead, Garrick.
That was a point that was made earlier. If the Home Office does require further reports, they will cover the cost. The point I was just going to make in relation to just picking up what the report that Herman just referred to. There's also real situation when an employer, if a person is off sick for a period of time, comes a point when the employer may have to refer that individual to an independent organization to assess what's happening to them. And there will be an audit trail for that evidence and record. And the organization that employer will use will be completely independent of the organization. And they would provide information as to, well, this person been off sick for 6 months, the employer has paid, the statutory requirement, etc., but the person is still not able to return to work. And so the employer would need to, consider the circumstance. And before the employer can deal with that, then they would need an independent assessment of the individual. And that would provide the basis whether the person illness prevent them from continue their employment, in which case then the employer will have to make a decision based on medical evidence that person no longer able to work for them. But that decision will be made on the basis of an assessment from an independent organization.
Thank you for that.
Thanks for that, Garrick. That was very good, the angle. Yes, because that's one that could be missed. It's quite important what we're going through here, where you've really got to have to sit down over sort of, I don't know, tea and biscuits type conversation, nice and relaxed, and these things come out. But yeah, but that last point, what Garrick has there, that's a very good one that could go, unseen.
Yes. The claimant is expected to cooperate with reasonable arrangements for obtaining such a report. The Home Office will meet the claimant's reasonable travel costs in respect of producing this report. The completed report will be sent to the Home Office, and you should send a copy of this to the claimant. And any questions and referrals to medical experts before we go on to the last subsection, balance of probabilities?
No, not at the moment.
Okay. Remember, the scheme operates on the balance of probabilities. That's very important. I'll come back to that in a minute. This means you can award compensation if you are satisfied. It is more likely than not that what has been claimed for occurred, such as you are more than 50% sure. They've explained it nicely there, what the balance of probabilities is and how it operates in relation to the scheme. So not because a claimant or not because S said, well, I was a bit distressed when my employer kept asking me, or the school kept asking me for my legal status. How likely is it that your children's school teachers will be asking you to prove your lawful status? Not asking your children, not because they need it for the children's enrollment, they're already enrolled. Asking you. How likely is it that S's employer kept asking her to prove her lawful status to work, or to be able to work? Can the caseworker reviewing that application be more than 50% sure that what S claims occurred or not? If it's no, then they would not have met the threshold of balance of probabilities, and therefore they would not be awarded any remedy. Moving on to the second paragraph. This means you should not expect customers to provide detailed documentary evidence to support every aspect of their claim or every criterion within a particular category. This is different from what we've experienced with claimants before from the Home Office. It did seem as though every criterion had to be met. So this is good to see it stated here, frankly speaking. However, as claimants, they still need to prove what it is they claim insofar as they can. And if they can't, why can't they? A good explanation is better than none. And lastly, you should take a holistic view of the claim and ensure that you use all the information and evidence available to you, including circumstantial information. That's the in the balance of probabilities. Any question on that? Yeah, Gareth, I see you have your pen up.
Yeah, this is a very good paragraph because you notice the point that you just read. This means you should not, you is the caseworker in the Home Office dealing with the case that comes in from the claimant. And this is why we've always stressed for people to be acquainted with the caseworker guidance, read it through. I know it's a lot of crazy to read through, but they need to be familiar with it because the caseworkers are making decisions, and unless you know how they're actually making those decisions, when your decision has been made, you wouldn't really appreciate what has led to that decision. And this paragraph actually says, this means you should not expect customers, the claimant, to provide detailed documentary evidence support every aspect of their claim. Very important.
Yes. And thank you for that, Gareth. I couldn't have said it better. So that brings us to the end of the impact on life section today and our case study of S. In conclusion, applying the information that we've went through to S's scenario of 1, her employer asking her to prove her legal status, and 2, her children's school asking her for her legal status or to prove her legal status. How can she then write or put the information together for the impact on life section? She could, 1, under the employer's request, so that she'd been asked however long to prove it, and this caused her, according to the first set of bullet points, she felt inconvenience. Her feelings were hurt, maybe embarrassed, humiliated because her counterparts and colleagues were not. So she felt singled out, I guess, for want of a better word. Did her mental health and physical health deteriorate, even though there were only 2 things that she personally knew that she experienced? Has she considered any of these others? And these are things we'll go through with her to consider and include under the impact on life section. One of the other things that she may be able to include is whether she lost her job or not, or whether that led to her termination. And if it did, we can include that. With regards to the children's school, because it's more probable than not that the employer would have asked her to prove her lawful status. With regards to the school, how likely? I've never really heard of that happening for children's school where they're already enrolled. So do you have any evidence of said? And what did it mean for your children's education? And how did that make you feel? And go through those bullet points and really explore those with her. Did she report it to the GP, for example? If yes, can we obtain a summary, specifically looking at anxiety, distress, annoyance, for example, worry? Was there any trauma? And going through it like that. We will go through the different remedies possibly and the description of what you'll need to meet in order to be considered for any specific remedy and what it'll look like. And again, going back to the very important test, balance of probabilities. How likely what you said happened than not. If a reasonable person who doesn't know you listen to what you have to say, would they say it makes sense? Would they say, well, yeah, I can see that happening? Well, no, I can't see that happening. That doesn't sound right. Oh, yeah, that's sad. Yes, that is right. Yeah, I can see that happening. Oh my gosh. That's essentially balance of probabilities. Those are the 2 extremes. Any questions? We have just under 30 minutes left, and I'm happy for us to finish early today. So yeah, Garrett, go ahead.
Just a point that you just raised in relation to the children and the school situation and the parent. Every parent, will be protective of their children and concerned about the welfare of their children, both physical and psychological welfare, etc. And if the parent, anxiety and depression has been treated with medication, for example, been prescribed antidepressant tablet, again, GP will have that information on their record. If the person had problem with their sleep, not able to sleep, again, that information will be on their record if they have a GP, and that has been reported. So the whole range of things that you can think that will affect the mother, the parent, and the children, because you can't separate what's happening to the children and the mother. You can't sort of separate that. One thing doesn't actually affect the other. and it's important that we capture that information, because that is the evidence that the caseworkers will be looking for as to how this has made this individual, the impact that individual have had through the situation at school, has resulted from X, Y, Z, and they will be even physical health issue that has developed as a result of the situation. And we always, we try not to. Used to be the case where physical health was treated as a separate thing. Now, physical health and mental health goes together, which is a holistic thing. So, you're treating the whole person, and there are different things that will affect the individual, but you cannot separate mental health and physical health. It does impact on the individual.
Thank you for that. It does. It does.
Yeah.
Yeah, go ahead, Herman.
I know there's a particular issues with regard to children in schools, and when there's impacts of various kinds, it could take up to 3 years before they're actually given a practitioner for, proper talking therapy and support. Yeah. Schools. So I know that would be, to capture that information would be very, very useful. Most parents will have to do as best as they can. But often the schools don't want to get children statemented and so forth because it costs them money. But basically, the NHS now, children now, various ages, they're having to wait. It could be up to 3 years or more. It's very rare, and it's a bit of postcode lottery. And in particular areas where you could say the demographics are greater for those from the Commonwealth with descendants, I can assure you it is 3 years plus. Yes, it's a very long time for a lot of that. But at the same time, it's actually capturing a lot of that information and reports inside there. So that's a good point that Garrick has made. But I know, listening and working with people who work in schools and actually advocates of various issues people have got with schools, especially with regard to Black and ethnic minority children, this is a problem. Yeah. And that often you'll find someone who's been denied going to college or university 4 or 5 years ago, and then there's a tipping point that when they really get about 18, they've fallen off the cliff, so to speak. So there's no help and support. But that particular episode they've been through has not really been documented properly, and where do you go to get the information and so forth? They need help getting that together. So it's just interesting what's been said here. I don't ask most possibly there's more questions as opposed to answers, but I know the questions have to be pursued in order to get the answers. Yeah, thank you for that.
You're welcome, Herman, and thank you for the contribution. Unfortunately, that is true. We don't have all the answers as individuals. Together, we can explore them, though. Together, it'll be easier. One of my experiences is that reviewing the guidance here, it has improved over the years from when the scandal first broke and the Home Office started in 2019 with the compensation scheme. It has improved. And it's good to see that, they are engaging and listening to stakeholders on how best to administer the scheme. There's still more to be done. This is by no means close to where it should be and could be. But we need to ask questions in order to pursue the answers, indeed, Herman.
Okay, that's great. If I could just make a point. So you won't be going on discretionary payments tonight, this evening?
No, we have 21 minutes to go. And what I think moving forward, thank you for asking that question to Herman. We're going to try to do it more as we did today, look at one section, depending on the question. So this is a case that came through recently.
Yeah.
And I thought it'll be helpful based on the limited information or lack of information and understanding on what is required to actually do a session on it. So
Yeah.
going forward, I think it'll be easier to use case scenarios or case studies to then go through the guidance, especially the sections I think are relevant. So it will help others if they're going to attempt filling out their claims.
That's good. An anonymous lived experience. I'd go
Precisely.
with that. Um, what's going to be interesting is I know the Home Office said they're reviewing with regard to applications and awards. It's going to be quite interesting that impact on life areas,
Yes.
especially when one could fall between that stool of 40,000 to 70. It's going to be quite interesting to see how many get pushed up from there or whatever. I don't know how that's been done. I know that's a bit different to it is in the vein of what we're talking about today, but it's something where they're supposed to be reviewing cases. I will be taking an interest in that for some people as well. So, yeah, as a
Yeah.
suggestion, today's been very good, I found, in a sense where I suppose as a form of this could be a first. Maybe you should get it sorted, get it painted in, because I think some of the live type anonymous experiences with just your dulcet tones or Garrick's tones, explaining them and going through them, they're like they could be used as a form of tutorial. Seriously, yeah. If he
We
was to revise how to answer questions and so forth, it's quite relaxed pace how it's gone, and even leave the interventions in if that was recorded in some way, shape, or form. I'm just thinking, I think as a legacy, something like that could be expanded on, but that's given me a few ideas. I'm just saying that because just for my background, because with regard to marking applications and bids for projects, and actually rather than always having to rack your brain all the time, you've got templates. I know it sounds a bit lazy, but it isn't, because you've got lived experience. And I used to go through that with regard to here's an example of why this bid was successful, why it wasn't successful. These are the reasons, these are the criterias, these are sort of the options it could have took, and so on and so forth. So I'm just saying from that point of view, and it maybe adds another stimulus with regard to what you and Garrick in particular, I know with Roland as well, what yourselves do. I would explore it before someone else nicks it, a big fat lawyer or somebody. So, because I think it's excellent, especially for advocates. Advocates need something like this as well. So, thank you for the time for going through that and actually putting forward your anonymous lived experience with regard to the client and so forth. And what was good from that as well, rather than maybe one person as well, why two, it was good getting those caveats from Garrick as well. Yes. I hope mine was some use as well, but that's me trying to stick my nose in. But what I'm saying, it's really, to me, it's like somewhat of an exemplar that and at a nice pace as well. That's what I'm sort of saying. The only thing when things get delivered and get standardized as whatever, and then money comes into consideration, things get moved on a bit quicker. So, but I'm just saying the delivery and so forth, excellence with regard to that. That's all I'm saying. With regard to what yourselves do, as to who, if one felt like it, to write to the funders, just with regard to an example, with regard to as a thank you, with regard to just to flag up situations like this, as to whom does one write to? Your bank manager, your parents, or ARE? Who does one write to actually? So that's actually it's noted. You understand what I'm saying? Because it's hard graft. You guys out here every Sunday. You're bashing this out
It's a
all the
good
time.
question. It's a good
I'm just
question.
saying. I'm not trying to cause any issues. I'm just saying. Yeah.
Thank you for your contribution, Herman. We I don't know where to start. You said a lot in there. So we report to who we need to report to with regards to any funding or grants that we receive. However, when we got into this, it wasn't for money or the grants because we didn't have any. We've been doing it long before the last year came out that the possibility grants came into play. We do it because we want to help people and we believe in what we're doing, and the people, the information needs to be out there. We have different skill sets and we wanted to use it to give back, at least in my case, to give back. I have an understanding of legislation and the schemes and how it, because of, for example, the schemes are created from immigration rules or immigration legislation.
Yeah.
How does an ordinary person who is not either legally trained or can understand legal jargons or the complicated, ambiguous aspects of the schemes in their entirety then complete an application form with the hope of being successful? Going back to a point you mentioned earlier about legal support being needed to complete the application forms.
Yeah.
Having said that, going back to question we report to who we need to, thank you for the suggestions and the compliments. We will take them on the advisement on board. However, one of the things I will say is that I don't think it will be any point necessarily creating audios because the schemes keep getting updated all the time. So what may be relevant today, like how we've had this session and we're recording for that purpose, we're going to put it on our social media, i.e. YouTube. So if people want to go see, they can look at it. Next month, what we've discussed here may no longer be applicable. And we'll have to do it again. So for that reason, I don't think it's necessarily worth going through the effort of creating a program. But the recordings will be there as evidence and memorialized in that way, at least digitally. So I guess that's one of the reasons it's being recorded. So all your interjections, Herman, they are noted and people will be able to hear and listen to them.
I know, I'm sure MI5 and MI6 are taking great interest.
MI7.
Oh gosh, is that a new one?
That's just the one for the Windrush people.
Hey, you might be right. Oh gosh, yeah. I'm just sort of saying because how it's chronicled in that sense. I just think because I know I'm a nuisance, but what I'm saying, I found them very, very useful. I mean, I've got a bit of a legal background with helping with people with that legal training and so forth. But even then, I don't like to just be in a silo. It's good to have other people and hear other convergent voices and so forth, and obviously with the experiences. And to tell the truth, there is some dark arts to this. I'm sorry, with regard to see how everyone has to look at this because how it's been set up. Getting to understand that and the nuances around that. But yeah, so it's appreciated. I know you said basically you had mentioned, Tanika, you want to get if we can finish early today, and you know me, I'll talk for England and the Caribbean, so you better get me off now.
It's fine.
Thanks, Garrick. Thank you.
We have 12 minutes to go, so it's okay. It's okay.
Okay, I apologise to anybody else on the line if I'm taking up the time space. If there's any
They're
other
all relevant points, Erman.
Okay.
There was one point that you just mentioned in relation to the Home Office reviewing cases, and this is a question, Tanika. As to your knowledge, has there been any review of cases that you have done, or cases that you are aware of over the last 12 months has been review or approaches been made by the Home Office in relation to any of these cases? Because that's what ought to be happening, but I don't know if it has started.
Not that I'm aware of. So not that I'm aware of in the sense that, one, they haven't approached our organization or any organization that I've worked with within the past 12 months that does Windrush work. And two, none of the clients that I've helped in whichever capacity, under whichever umbrella, no client has reached out to me and said, well, Tanika, they've just reached back to me and need to know for the information, or they've offered me whatever to know. They said they've done it. Unfortunately, the Home Office has said a lot in the past.
Precisely. And I'm trying to look for the evidence, where if there are cases where, we can identify that they have done it, or is it something that is in the pipeline but has not yet been enacted? Unfortunately,
your guess will be as good as mine, Garrick, and I do not like to guess nor give my mouth liberty on certain things. It's not going to be beneficial to anyone to do so. I guess if and when they do it, hopefully they'll make it publicly known by maybe putting an announcement, and we'll be able to find it, and then we'll know, well, yes, here's some evidence they've said this or they've done that.
And Norman can do the same thing. If you do hear of any cases that has been reviewed, then share that information, let us know.
Yeah, I'll do that. I've tried to put some feelers out to some individuals as well. I know want to have had some success with their claims. So because I've had a lot on recently, and it did come before the election that I think we did talk a bit about this. I think this came up in the group, the Sunday chat before, and with regard to evidence of them doing that, because they've stated it, they were quite bullshit about it, the Conservative government, say that was going to be done, but I'm not aware of anyone at all who've actually had that approach yet. Yeah, so but we need to be aware of that, 'cause people may well be missing out, and there may well be some complications with that as well, I suspect as well. If some people pass and all the rest of it, it's, still anyway. Thank you for today.
I suspect also, Erman, that the Home Office probably going through some changes, internal changes with the new government. So, it's probably early days. Not expecting to see big shift immediately. It's only 3 weeks into the new government, going into 4 weeks, etc. So maybe over the next few months, we might see, some new initiative and new direction coming from the new Home Secretary, etc.
Yeah, it'd be good getting in, if getting involved in some discussions of that. I know you guys at a senior level to ask some questions on that or be involved in the meets, but that's going to be an important aspect. So I think hopefully maybe after the party conferences or something, we need that. But I'm just aware if we let it slip beyond, the end of the year, it's going to cause a few issues. I know they've got a lot on their plate in so many ways at the moment.
Yeah, absolutely.
This one has been there and should not be. It should be. There should be still some room on the plate. It shouldn't slip off the plate, basically. All right, then. Well, thank you, guys. Thank you, guys. Thank you.
Yeah. So just by way of an update and announcement, from September 2024, we will be moving our Windrush Q&A sessions from twice a month to once a month. And we'll do it on the first Sunday monthly. We've had nearly a year of doing it twice a month, and we have not had the uptake that we'd expect for whatever reason. So until further notice, we'll just have it once a month instead, the first Sunday of every month. If we still do not receive questions prior to that, we will do what we've just did, maybe give a case study or use a scenario or go through updates or schemes. But we will advertise and announce what it will be focusing on that session. We'll record it and we'll be putting it out on our social medias accordingly. So I'll give us a bit more time to prepare and to be able to do more stuff, given the fact that we have events on from now to November, along with other commitments. Speaking of events, we have an event coming up this Saturday, the 10th of August, from 10 a.m. to 3 p.m. in Liverpool. All are welcome. Please RSVP. We will be sending out the links, or please visit our website or give us a call. And if, for example, or for whatever reason, due to what's been happening in the country, we cannot go ahead with the event this weekend, we will make that known. We are watching and waiting and seeing what advice comes out from the government, so we'll know how to proceed accordingly. The last thing we want to do is to put anyone in danger or cause anyone to be in danger. Sorry, let me correct that.
Okay, I'm hoping to make an event in Liverpool, so at some time that would be useful. Would there be a bit of slack in the sense if something comes up, a particular issue as such, where we could contact yourselves? You never know, you might have a flash You might have an
Newsflash.
urgent Zoom or something. Yeah,
Sure.
something like that. But just in case, I'm not saying anything untoward, but just in case there was a real pressing issue, there was a bit of stack. But
Absolutely.
I understand what you're saying, and I've been guilty of not actually, I suppose, forwarding some questions, because sometimes even within the week, there's been slight changes. There's some issues because various organisations or advocates have heard this, that, or the other. So often I like to hear it just from yourselves. What have yourselves heard officially? So that's helpful. Okay, I'll make note of that. It means we're going to have withdrawal symptoms, but we'll have to deal with it in some way, shape, or form.
We're still available to be contacted, Erman. So that
Yeah.
doesn't, you don't lose the contact.
Yeah, I know. I'm only jesting. Okay. All right then. Well, thank
Not
you.
a problem. You're most welcome and thank you. Have a great evening, everyone. I hope today was useful. And if you have any questions based on anything we've said today, please feel free to send us an email. We will respond. We will answer your questions. If there's something that you want us to look at for next time, our next session is the third Sunday of August, and that will be the 18th of August. The 18th
Wow,
of
my
August will
birthday.
be happy birthday in advance. My birthday's not long
Brilliant.
after yours.
Okay.
So you bring the cakes then, Erman.
How can we sort out a virtual cake?
A virtual cake down the internet.
My condolences with regard to my uncle.
Sure,
So it's good doing something like this. Help takes my mind off it. It's been quite intense the
Yeah.
last
God
week
bless
on
you.
that. So
You're
I
most
needed
welcome.
something like this to unwind. Thank you very much. Take care. Look after yourselves. God
All
bless.
right.
Thank
Yeah.
you.
Have
Good
a
night,
good day then.
everyone. Thank you.
Take
Bye.
care. Bye.
Bye-bye.
Bye.
Bye-bye.
Bye. Bye.
Bye.